Hello, everyone. Welcome to our session on contract law. Today, we will discuss exclusion clauses and interpretation of contracts. What are exclusion clauses? A clause in a contract or a term is in a notice which appears to exclude or restrict a liability or a legal duty which would otherwise arise is called an exclusion clause. An example of an exclusion clause is no liability is accepted for any damage, howsoever caused to any goods during the course of transit. Why parties have exclusion clauses in their contracts? So what are the functions of exclusion clauses? An important function of exclusion clause is that it allocates risk within the contract. Exclusion clause also help reduce the chances of litigation, and by doing this, it reduces the cost of commercial transactions by making clear that the responsibility is properly divided between the parties. Through exclusion clauses, parties make sure that who will bear the risk of a particular deal. These clauses are used as standard form by enabling people to mass produce such contracts to help reduce of cost negotiation and making contracts. Because these are standard terms, you don't have to reinvent the wheel every time. So these are just there and everyone knows about them. So in this way, you can simply incorporate existing standard clause in your contract and exclude your liability. You don't have to every time customize a particular clause. However, there are problems with exclusion clauses because they enable powerful parties within the commercial sphere to exclude their liability at the cost of weaker parties. So therefore, there are, as we will explore, lots of rules and regulations which try to regulate exclusion clauses to what extent one can exclude one's liability. So these are the three important subtopics that we will discuss today. How exclusion clauses are incorporated into the contract. So what are the ways and means to incorporate particular clause into the contract? Was the clause part of a contract? Was it independent of it? If it was part of the contract, whether when the contract is breached, this exclusion clause stands there, or it also is basically declared null and void when the contract becomes null and void. Is there any separability between the exclusion clause and other clauses of the contract? And once exclusion clauses are incorporated into the contract, how courts interpret them? Do they interpret them restrictively, or they interpret them liberally? Does the wording of the clause actually cover the liability in question? To what extent you can exclude your clause? So what are the effects of incorporation of exclusion clause into a contract? And then we will explore certain statutory controls over exclusion clauses, which are provided in the UK under Unfair Contract Terms Act 1977 and under Consumer Rights Contract Act 2015. So, incorporation. An exclusion clause could be included into the contract when contract is signed and attention is drawn of the other party towards the existence of exclusion clause, and sometimes previous dealings of the parties where exclusion clauses are included are also regarded as incorporation of exclusion clauses into the contract. Let's look into the details. Signature. there's a general rule that if you sign a document, you're bound by it. So by simply signing a document which contain exclusion clauses, you become contractually liable to or bound to those exclusion clauses. And then there is a requirement that reasonable and sufficient notice of the existence of exclusion clauses must be given at the time when document is being signed. There are two requirements that need to be satisfied. First, the clause must be contained in a contractual document. Acknowledgement of payment, for instance, voucher or receipt, is not a contractual document. So exclusion clause must be part of the contract, not something separate from it in the form of voucher, acknowledgement of receipt, or some other document. Second, the existence of exclusion clause must be brought to the attention or notice of the other party before or at the time of the contract is entered into. It must not happen after the contract has been entered into. In one case, it was held that if it is proved that at the time the contract is made, the claimant has actual knowledge of the existence of a term, then she will be bound by it. If it is proved that at the time of the contract made, claimant has no actual knowledge of the existence of a term, then she will not be bound by it unless she is deemed to have such knowledge, and she will be deemed if she has been given reasonable notice of it. Previous dealings of the parties where they had exclusion clauses would be regarded as valid. So even where there has been an insufficient notice, an exclusion clause may nevertheless be incorporated where there has been a previous dealing between the parties on the same terms. So here is a graphic description of what we have covered so far. An exclusion clause could be incorporated into a contract when that contract is signed by the parties. Reasonable, sufficient notice is given of contractual exclusion in contractual document before or at the time of the contract, not after the conclusion of the contract. Sometimes previous course of dealing between the parties is regarded as valid incorporation of an exclusion clause, so far as the previous dealings are consistent, regular, and frequent. Now, that was the first part of our session. That was about incorporation. Now, let's move on to the second part, that is about construction or interpretation. The basic rule is that liability can only be excluded by clear words. So if there is an exclusion of liability, clear, unambiguous words must be used. There is this rule which is called contra preferentum. It says that any ambiguity in the wording of an exclusion clause will be construed as narrowly as possible against the party purporting to rely on the clause. We also have this doctrine of fundamental breach. An exclusion clause could not protect a party from liability from a serious or fundamental breach of a contract, even where on its true construction, the wording of the clause covered the breach which had occurred. There are two approaches to this doctrine. The rule of law, under which it was not possible by a clause, however widely drafted, to exclude liability for certain breaches of contract which were deemed to be fundamental. Lord Denning formulated this approach as a means of control over exclusion clauses which were thought to be unreasonable. The second approach is the rule of construction approach. The question whether an exclusion clause covered a fundamental breach was a question of construction under which the clause was interpreted against the party seeking to rely on it. So it's a reformulation of the rule of contra pro fronte. Here are the manifestations of the rule of law approach. The rule of law approach was ever rejected by the House of Lords in Suez Atlantic case. It was held that there was no rule of substantive law that an exclusion clause could not cover a fundamental breach. It was a question of construction whether a clause in fact covered the breach in question. The Court of Appeal, however, revived the fundamental breach doctrine in Horvath's case, where Lord Denning held, when one party has been guilty of a fundamental breach of the contract, that is, a breach which goes to the very root of it, and the other side accepts it so that the contract comes to an end, or if it comes to an end anyway by reason of the breach, then the guilty party cannot rely on an exception or limitation clause to escape from his liability for the breach. However, Lord Denning's rule was overruled by the House of Lords in Photo Production Limited versus Secular Transport Limited, which reaffirmed Suez Atlantic judgment. In photo production, the claimants employed the defendants to protect their factory by a visiting patrol. A clause provided that under no circumstances shall the defendant company be responsible for any injurious act or default by any employee of the company. One night, one of the defendant's guards lit a small fire inside the factory, which got out of control and completely destroyed the claimant's premises with a loss amounting to £165,000. The House of Lords held that though the defendants were in breach, they could rely on the clause as it is clearly and ambiguously covered the breach in question. It was held in commercial contracts negotiated between businessmen capable of looking after their own interests and of deciding how risk inherent in the performance of various kinds of contract can be most economically borne, generally by insurance. It is, in my view, wrong to place a constrained construction on words in an exclusion clause, which are clear and fairly susceptible of one meaning only. Please note that this doctrine of fundamental breach is of historical relevance. There is no such rule in English law anymore because we have a statute on that point. And the statute is called the Unfair Terms Act 1977. The purpose of the act is to restrict the extent to which liability in a contract can be excluded for breach of contract and negligence, largely by reference to reasonable requirement, but in certain cases by specific prohibition. How about the liability for negligence? Liability for death or personal injury cannot be excluded under no circumstances. Exclusion or restriction of liability for negligence is permissible insofar as the term or notice satisfy the requirement of reasonableness. Contractual liability, where one party deals as a consumer, so the act differentiate between consumer contract and business contracts. So where one party deals as a consumer or on the other party's written standard terms of business, then the other party cannot exclude or restrict his liability for breach of contract except subject to the requirement of reasonableness. The reasonableness requirement also extends to terms purporting to entitle the other party to render performance substantially different from that reasonably expected, or no performance at all. Sale of goods and hire purchase contracts with respect to title. In contract for sale of goods and hire purchase, the implied term as to the title of the property cannot be excluded. So you cannot say, I'm selling you this property, but I'm not sure whether it belongs to me or not. You cannot exclude your liability with respect to the title. With respect to quality in consumer contracts, liability for the implied terms as to correspondence with description or sample fitness for purpose and mercantilability, quality cannot be excluded. Such liability can be excluded in non-consumer contracts insofar as the test of reasonableness is satisfied. Now, what is reasonableness? The 1977 Act does not define reasonableness, but in order to determine reasonableness tests, courts must take into account the following factors. First, the bargaining position of the parties. Second, whether the customer received an inducement to agree to the exclusion clause, for instance, lower price. Third, knowledge of the customer regarding existence and extent of the term. Fourth, whether the goods were manufactured, processed, or adapted to the special order of the customer. And fifth, whether it was relevant at the time of the contract to expect that compliance with the condition would be practicable. So here are facts of one case in order for us to understand what is reasonableness and how is it applied. Finilock Seeds Limited agreed to supply George with winter couch seeds for £201. An invoice sent with the delivery was considered part of the contract and limited liability for replacing any seeds or plants sold if it were defective, and excluding all liability for loss or damage or consequential loss or damage from use of the seed. Crops failed and £61,513 was claimed for loss of production. The two main issues in the case were, first, whether the limitation clause should be interpreted to cover the seed actually sold, given that the seeds were wholly defective. And second, whether under the Unfair Contract Terms Act 1977, the limitation was reasonable. The court held it would not be fair and reasonable to rely on the exclusion clause and decided in favor of the claimant. In another case, it was held that a disclaimer of liability used by surveyors in relation to building society evaluations was unreasonable. Lord Griffiths held that in deciding on the issue of reasonableness, four questions should always be considered. First, were the parties of equal bargaining powers? Second, in the case of advice, would it have been reasonably practical to obtain advice from an alternative source, taking into account consideration of cost and time? Third, how difficult is the task being undertaken for which liability is being excluded? Fourth, what are the practical consequences of the decision of unreasonableness? In another case, it was held that where the contract was negotiated between experienced businessmen of equal bargaining power and skill, the court upheld exclusion, and limitation clauses. That was in 2001. Therefore, Unfair Contract Terms Act 1977 appears to be a consumer protection legislation because its scope for clauses in commercial contracts negotiated on equal terms is extremely limited. Now, the 1977 Act excludes specifically certain types of contracts which are provided in Schedule 1 of the Act. They include international supply of goods, insurance contracts, land contracts, interest in intellectual property, securities, and there is also limitation on international scope of the Act. The Act does not apply to foreign parties who choose UK law by choice, but the rules which regulate attempts to exclude liability for misrepresentation are applicable to such contracts. But the UK parties cannot evade the application of the Act by the choice of a law outside the UK as the governing law if it appears that the choice of law was imposed wholly or mainly to enable the party imposing it to evade the operation of the Act. Having looked into the exclusion clauses, now let's look into the topic of interpretation of contracts. Research shows that 99% of litigated cases concerning commercial contracts turn on questions of interpretation of contracts. So most litigation happens when parties quibble or dispute certain meanings of the contract. So that's why interpretation of contract is really important. It's not sufficient that you have negotiated and written down a contract. Your problems may actually start when contract is being interpreted. And as we have seen in a number of rather overwhelming majority of cases, specifically in commercial sphere or even non-commercial sphere, with respect to contracts, the issue revolves around interpretation. Courts have been dealing with these issues over a period of time, and they have also developed certain rules. And now we will look into those rules which courts rely upon. Before we look into the rules, let's ask ourselves that why do written contracts cause such a problem? Do the parties always not say what they mean, or do not always mean what they say? Do lawyers write the contracts and don't know what the parties mean? Is it the indeterminacy of language in general? Do the courts lack a consistent approach to interpretation of the express terms of contracts? Do the courts try to secure a fair result regardless of what contracts say? What contract says? There are three main theoretical approaches to the issue of interpretation of contracts. The first one is subjective intention, where a search for the actual intentions of the parties to the contract is undertaken. So judges place themselves into the shoes of the parties and try to see what were the subjective meanings of the contract in that particular context of a contract that is disputed. Second is literalism or formalism approach, an application of the literal meaning of the words contained in the document, irrespective what the party's subjective intention was. So the golden rule of interpretation is that you just look into the ordinary meanings of the language and try to apply them. The third is the objective promise approach, an inquiry into what a reasonable person or the reasonable promisee would have understood to have been the meaning of the word in a particular context. The question here is that do we need law on interpretation of contracts? We already have contract law. Then we also saw we have Unfair Contract Terms Act 1977. We in Pakistan have Contract Act 1872. We also have consumer protection regulations. Do we also need a separate law which deals with the interpretations of contracts? First, it is desirable and fairness demands that different judges and the same judges in different cases should reach the same answer on any legal question. In order to ensure certainty and fairness, we must have predictable meanings put into the contract. Second, people who make contracts are entitled to know what the courts will say that they mean if a dispute should arise. Third, it is in the interest of the parties to a contract and in the public interest that judges should impose some restraint to prevent time and money being wasted in considering a mass of irrelevant material. Remember, we have this parole evidence rule that generally, if a contract has been written down, then courts will not take extrinsic evidence into account. They will try to gauge, assess the meaning and the intention of the parties from within the four corners of the written down contract. And the justification for that rule is a policy consideration because courts don't want to waste their time by looking into extrinsic evidence. That might be drafts, that might be negotiations, that might be witnesses and all that, with certain exceptions, of course. So if that rule is read here with this, with respect to the law of interpretation of contracts, then definitely we need rules which may guide judges and which may also provide some guidance or guidelines to the parties that how their contracts would be interpreted. There are certain rules of interpretation of contracts, just like full subject is taught on interpretation of statutes. There are also rules with respect to interpretation of contracts. The first and foremost rule is that intention of the parties must be taken into account. Second, the surrounding circumstances of a transaction or a contract must be taken into account. Third, unreasonable results must be avoided. Courts can take into account the consequences of one interpretation or the other and try to put certain meanings based on the consequences. Fourth, the market practice, custom or usage must be notorious, certain, and reasonable, and in effect, such as it regarded as binding in trade in question while interpreting the contracts. Remember, this requirement is a very strict requirement. So the custom or usage must be certain and reasonable in order for it to play a role in helping judges in interpretation of contracts. So that is it for today, and we shall discuss this in our seminar in